theknowledgegroup.org, and a continuing education coordinator will be able to assist. Now, a couple of quick questions here that dropped in from our attendees. Eugene, this is one dropped in during your segment here that's open to both of you. Now, what does the Flook really say about equations always being used in prior art?
Right. So Flook, I consider the biggest obstacle to software eligibility, and macro is the most favorable. In Flook, they said that if you have an equation, and this is sort of based on Benson and Morse, where they said if the equation represents a natural law, then you have to consider a natural law in the prior art, and therefore it cannot provide novelty. And so what Flook said, that any equation should be considered to be in the prior art and cannot provide novelty. That's in direct opposition to my example of a new equation where you derive humidity from temperature. That is not in the prior art. It shouldn't be considered in the prior art. Novelty should be based on that. And the guidance does allow us to have the novelty in the judicial exception as long as confined to a practical application. So you have to deal with Flook in that case. And the way to do that is to limit Flook to its fact pattern where there was no hardware recited, and the computation could have been done in the human mind, and don't take that overly generalized statement from Flook. Keep it in the context of no hardware required kinds of steps and mental steps exception.
Thank you so much, James. A quick question that dropped in during your segment here. And what are one's options if one was to think an examiner was perhaps not adhering to the guidance?
Sure. So it's actually touched on a little bit in the October 2019 update. Some of the feedback that USPTO had on the guidance was that essentially that they weren't directly able to appeal, an examiner's failure to adhere to the guidance. When what they clarified there is that essentially you're able to appeal rejections, including 101 rejections, as long as any claim has been twice rejected. And there you essentially, you can't really challenge whether the examiner is following the guidelines or not, but of course you're challenging whether the rejection under 101 is proper. And so in a sense there, if the examiner has improperly rejected a claim under 101, which wouldn't be eligible regardless of the guidelines, this can still be appealed. So some other things to keep in mind are that perhaps you might consider an interview with the examiner or speaking to his supervisor. Each of the technology centers have a designated expert on 101 that the examiners can refer to, and so there's really a number of options. But if you find yourself, in the situation where an examiner is maintaining 101 rejections, then appeal is an option.